Well, thank you very much, Stephen. Ladies and gentlemen, we've heard the background now, and we've heard about the history and the background to the politics and the jurisdiction of the Tribunal. Let me just explain how I became interested in the Tribunal. Then what I propose to do is take you through very briefly what are the four organs of the Tribunal and have a brief glimpse at what are essentially the most controversial provisions for some, the in absentia provisions. Well, as Tony said, my interest background has been in the last 10 years involving a number of terrorism cases in the UK which have had a number of international aspects to them. And when I heard about the Lebanon Tribunal, it certainly interested me. Having become a list counsel on their list in The Hague, I received, as seems to be the way, a phone call or an email out of the blue with an invitation to go to the Lebanon. And in June this year, I was instructed as part of a United Nations mission to go to Lebanon to take part in a number of conferences there where the Defence Office discussed with local lawyers the workings of the Tribunal. It then became clear to me what was in the minds of the Tribunal and the Defence Office, namely the in absentia provisions. I was asked to consider the rights of the accused, the in absentia provisions, and this is something that was discussed often during the course of the week there. And 2 weeks ago I spent another week in The Hague, and again I was asked to talk about in absentia provisions. So you don't have to be a brain surgeon to realise that the Tribunal are foreseeing that when these trials start, there may be few individuals sitting at the back of the court in the dock. There is a real likelihood that you are going to have non-cooperation of states that may have accused, and you may have trials without accused taking part. So let's now look at the four organs of the Tribunal. Well, we know that's Rafik Hariri, that's how it all started in 2005. This is the building in The Hague, on the outskirts of The Hague, where the Tribunal is based. You may have heard of it recently in the media because lovely Naomi Campbell was giving evidence there, being cross-examined by Courtney Griffiths in the Taylor trial. They have effectively borrowed the Lebanon Tribunal's building, so the Lebanon team are all in there, but that's certainly where the Taylor trial has been taking place. If we look at the four organs built into the statute, we have the chambers, the prosecuting office, the defence office and the registry. It's a world first really to have, I think, a defence office as part of the organs of the Tribunal. Let's look at the other organs in turn. Well, the chambers. The chambers are comprised of one international pre-trial judge, similar to a juge d'instruction in France. And then you have a trial chamber, which is composed of three judges, one Lebanese and two international. In the appeals chamber, they have 5 judges, 2 Lebanese, 3 international. And the presiding judge of the appeals chamber is also the president of the Tribunal, who have been well known to many of you, President Kassesi. The second organ, the office of the prosecutor, is made up of a large team of lawyers, counsel, investigators who we're told are very busy right now, and we're all hoping that they're on the point of bringing some accused, either physically or not physically, but to the attention of the Tribunal in The Hague. Certainly, in terms of the third organ, the Defence Office, as I mentioned, they have a number of people there who are effectively providing support and assistance to Defence Counsel. They are comprising just now and have about, I think, 60 or 70 counsel already on the list, who are counsel, whether it's solicitors or counsel barristers from all over the world. And these counsel will be supported by the Defence Office, who effectively will be providing legal research, helping with collation of evidence, advice, helping with provision of experts, and so forth. And they will undoubtedly be a very important part of the Tribunal. They are headed by the French avocat François Roux, who I think we can see shortly. And they have a very excellent team of international lawyers and researchers who are there to help once the trials start. The fourth part of the tribunal is the registry, and effectively this deals with the non-judicial aspects of the administration of the tribunal, such as the coordination, mediation. It provides facilitation, it sorts out the interpreters and the like. For example, the languages. When I was in the Lebanon for that week, the languages in the conferences were Arabic, French and English. Now if you wish to apply to be a counsel, or if you wish to apply to be an investigator, you may be interviewed, and the interview may be in English and French. So don't be surprised, you may need to have some either Arabic or French skills if you want to become part of a team. Because as lead counsel, once you're instructed, you would be required to put together a team, and that would comprise of a co-counsel, in other words, a junior counsel, perhaps a consultant, an international lawyer, you'd have an international research student, you'd have investigators. So the registry is the engine room of the tribunal. Let's move on very briefly. That's François Roux, who is an extremely impressive individual who is behind the Defence Office. Unique features. Well, it is a world's first. It's effectively, Stephen says, it's the world's first terrorism court, and the eyes of the world will be upon the STL. And secondly, whilst the international in nature, we know that it will be applying the national provisions of the Lebanese Criminal Code. Although, in fairness, if one looks at the rules themselves, as Gillian and Stephen will say, as I understand it, a lot of the rules seem to be a cut and paste job from the ICTY, but certainly they're meant to apply the provisions of Lebanese code. And indeed, if you're putting a team together, it's probably going to be essential to have a Lebanese lawyer working with you. Then the third unique feature, in absentia provisions, which I'm going to come on to, and fourthly, the introduction of the Defence Office as an organ of the court. I'm going to take this very briefly. We have a USB for those who are interested with the presentations. If anybody wishes the details of these provisions, they can be emailed to everybody. The main provisions relevant to in absentia, Article 16, rights of the accused, and Article 22. And these rules in the statute in Article 22 are amplified in the rules of procedure, which are found in 103 to 109. I won't go to Article 16. As Stephen said, they're the basic rules that you find in all international tribunals. Article 22, this is the crux of the in absentia provisions. And they make clear under Article 22.1, the tribunal shall conduct trial proceedings in the absence of the accused if he or she, and there are three particular instances which they envisage. Firstly, if he or she has expressly and in writing waived his or her right to be present. So if they waive the right to be present, and that's assuming there is contact with an accused, then a trial may take place in absentia. The fact it's in absentia is very important as a matter of law, because if there is an in absentia trial, there is an automatic right to a retrial, which I'll come back to later. Presumably, if there is a waiver from an accused, the STL would want to ensure that the decision to waive the right to be there was taken freely and that the accused has had legal advice. Secondly, there may be an in absentia trial if the accused has not been handed over to the tribunal by the state authorities concerned. Now, in relation to that, the tribunal would have to be satisfied that the concerned state failed to cooperate within a reasonable time and that all the necessary steps have been taken to ensure the presence of the accused and their participation in the most appropriate way. One interesting consideration that they've been looking at is whether or not you can have a trial effectively by video link. By video link. Now, we're used to having video link hearings, but this tribunal is seriously considering trial by video link. The third option, where you may have a trial in absentia, is where the defendant, and this is something we're used to in England, where a defendant has absconded or otherwise cannot be found and all reasonable steps have been taken to secure his or her appearance before the tribunal, to inform him or her of the charges confirmed by the pre-trial judge. Now, in England, we're not, I suppose, institutionally used to having in absentia trials. In Lebanon, it's very different. The culture is very different. There's a civil law system. As it is with Italy and Belgium, they do have in absentia trials. So here, I suppose, it's an alien concept, but very familiar to Lebanese lawyers. In relation to absconsion, again, the tribunal would have to satisfy itself that reasonable steps have been taken to secure the attendance of the tribunal. Right, let's move on to Article 22.2. Now here, where the accused, hearings are conducted in the absence of the accused, the special tribunal shall ensure notification. Of course, that's if it's possible. And they foresee, and there may be challenges to this, not necessarily, although one would hope, an effective notification directly, but they foresee some sort of notification in the media or communication in the state of residence. One can foresee all sorts of problems with that. And secondly, they also draw a distinction in Article 22.2 between situations under B where the accused has designated a defence counsel of his or her choosing, or whether in C they effectively don't make a decision, they make no choice, but the defence office appoints counsel. There's a big distinction between the two. If the accused chooses his or her counsel, then they forgo the right to a retrial. If they, on the other hand, make no decision and allow the tribunal to appoint counsel, then there is a right to retrial. So there are quite considerable consequences. We've dealt with that. Looking at Article 22.3, it sets out the right to a retrial. If an accused is tried in absentia and then suddenly appears in The Hague, they have a choice. They could either accept the conviction, they could accept their sentence, or they can say, I want a retrial. If they win in The Hague and the prosecution appeals successfully, they can still ask for a retrial, or they can accept the successful prosecution appeal, as unlikely as that may sound. In terms of the rules of procedure, so there should be proper notification, representation, the right to be retried. Rules of procedure, I'm not going to go through this for reasons of time, but the main rules are set out here: 103, 104, 105, 106, up to 109, and they give some more detail to the statute. One interesting area, which we were debating when I was in Beirut and in Tripoli, was a situation, and there isn't really an answer to the question, although I tried to give one, which is, if you have a situation where a trial is taking place, you have no contact with the accused, so on the face of it, he's entitled to be having a retrial, and then you get a phone call. Mr. Young, I've been watching you on television, because these proceedings may be on the internet. And they're watching you on television, they may be saying, well, it's going well, but I'd like to give you some ideas here. I'd like you to deal with this, I want you to deal with this witness, I want to instruct this expert, and can we deal with it in this way? You have to say, stop. There isn't a code of conduct yet finalised for the tribunal, but there are serious ramifications. My advice to Francois Roux was this: